So what happens when you are in your Chapter 13 bankruptcy case and you want to sell property, not real estate, so not a home, not a piece of land, but you want to sell an item? Usually we get these requests when it's a vehicle. So let's talk about why that would happen. So, Chapter 13 cases, you could be in a case for 5 years. That's typically the length of a Chapter 13 case. So during that time, something could happen with your car, or maybe your car kind of not working great and you're like, I need to trade this car in. I need to sell it and get something else. Well, you can do that. You can most definitely do that, but there, like everything in bankruptcy, there's a process. So pretty much similar to the motion to sell real estate, the motion to sell property is going to work the same. So first thing is we need to know what you're going to sell. We need to know who you're going to sell it to. If there is an agreement, we need to see a copy of that agreement. So if you go to our website and our Chapter 13 client portal, you will see that. It is there. So you will fill out that form and you will upload the proof of the transaction, what you want to do. Don't do it until you have court permission, but we do need that information. Now, a lot of times with the cars, that car is also being financed through the bankruptcy. And if you are in the bankruptcy, there's a good chance that you are not having to pay back all of your interest. Or maybe we've actually crammed the value of the car down to just what it's, or the repayment of the car just down to the value. So most of the time, cars in bankruptcy are not being repaid at what you had contractually signed up for. If you want to sell that asset, however, and get, traded on something else, then on the motion to sell, yes, we can sell it. And that claim, whatever the funds are that you're going to, trade it in for or whatnot, just understand that the payoff for that car, if it's still being financed, is your original amount. It's not going to be the great deal that you got in your bankruptcy case. Because in order to get that deal in the bankruptcy case, you got to finish it. But if you're jumping the gun and you're wanting to sell it before the case is over, then you lose that deal. So just be aware of that. Because sometimes people think, I don't, the value is only $3,000. That's all I was paying. And so I'm going to sell it and I'm only have to pay this. Everything goes back to the way it was. So be aware of that. So if you're going into like a CarMax or one of those places, you need to let them know whatever your original contract was, that's going to be the payoff if they're going to pay it off and then finance you in a new car. By the way, if you're going to do something like that, you also have to file a motion to incur debt to get that transaction approved as well. So there's two motions to sell and motions to incur. Yes, I know you're like, good grief, lawyers and their motions, but those are the rules. I didn't write them. I just have to enforce them. So just heads up, if you're going to do a transaction like that, just be aware. Now, you could be one of those people that you may have a car that's paid off and you're like, look, I just want to sell the car and use the money to maybe get a more affordable car, or sell the car and put a down payment on a car. That's fine. But again, we have to have the same thing. We have to know the transaction details. And then we have to, whatever money you're going to make from that, we have to show proof of what you're going to use it for. Because if you're just wanting to sell it, then the court's going to say, you have to take that money and pay it into your bankruptcy case, so that you can either pay some unsecured creditors back that weren't getting paid, or you can just get out of the case faster. It depends on how your case was written. And this is really why it's important that you sit down with your bankruptcy attorney and understand exactly who you're paying back, how much, if you're a 100% plan, a 0% plan, a 20% plan, a 36-month plan. There's all these different hitches. So make sure you're speaking with your attorney to understand how that works. Other than that, it's still about I tell folks, give yourself 45 to 60 days. On our website, we literally have a little graphic that shows the process to walk you through. This is the motion timeline, because a motion first you have to submit all the required information. That's the big deal. So if you don't, then we can't do anything. But once you do, we file the motion. We have to get on the judge's calendar. The motion is heard. If everybody's okay with it, then an order has to be submitted for the judge to sign off on. The judge will sign off on it, and then you have the order. You can then sell the property. Then you have permission. Do not go do a sale and then come back and ask the court to retroactively grant it. You're seriously going to piss everyone off, and you could have major sanctions for it. Your case could even get dismissed for it. So just make sure that if you're contemplating something like this, it's doable, totally doable, but there's a process and there's a procedure. So just make sure you follow the rules.